Well, good afternoon, everyone, and welcome to today's webinar, Claiming Your IEEPA Tariff Refund, the Nuts and Bolts, hosted by Saul Ewing. My name is David Shapiro. I'm partner and head of our tax practice based out of our Philadelphia office. I'm joined today by my colleagues, John Baruchian and Joe Valenti, to share their insights. John is a partner based out of our Boston office, and Joe's a partner based out of our Pittsburgh office. Our contact details are available in the Resources tab at the bottom of your screen, and we will be sharing them as well after the presentation. So before we begin, a few housekeeping notes. First, if you've got questions, please use the Q&A tool at the bottom of your screen. We encourage you to submit questions at any time during the program. We'll keep an eye on submissions throughout, and we'll address as many as we can during the discussion at natural points in the discussion. If we can't answer your question during the discussion, we'll try to follow up with you by email afterward. After the program, in the coming days, you'll receive a follow-up email from our team with the webinar recording, slides, and our contact information. And of course, because we're lawyers, we have to offer a disclaimer. The provision and receipt of the information in this program is not legal advice, does not create a lawyer-client relationship, and should not be acted on without seeking professional counsel who've been informed of your specific facts. And with that, let's get started. And I'm going to hand it off to Joe Valenti to give us a little background.
Thanks, David. First off, we wanted to talk about the scoping today, and this really starts with February last year. The president issues 3 executive orders imposing tariffs on imports from Canada, Mexico, and China that are premised on IEEPA and the idea that there's a national opioid crisis that creates the emergency that allows these trafficking tariffs to exist. Shortly after that, there was another national emergency declared in April of 2025 for the trade deficits with trading partners. And that was what resulted in the reciprocal tariffs. People are probably familiar with the picture of the president and the big chart and all the percentages from that issuance. So as we go through the presentation today, we are specifically discussing the IEEPA tariffs that arose under these orders. And each of those orders directed the Secretary of Homeland Security to alter the harmonized tariff schedule of the United States for these tariffs. And then just a few more background things. IEEPA ties to economic emergencies. That's what it is, the International Economic Emergency Powers Act. And this doesn't cover all tariffs under IEEPA or all tariffs generally. There are still many tariffs that exist, are perfectly fine, constitutionally authorized, etc. But what we'll be talking about today stems from these orders, and these are the ones that really got a lot of attention because they were tariffs on countries that typically did not have tariffs, tariffs on industries that typically did not have them. But we did want to note that at the outset, some of these tariffs that have long been in existence are not governed by the decisions and the appeals that we're talking about today. There are tariffs, for instance, up to 15%, tariffs that are supported by a commerce investigation, such as ones into steel, and the idea that even though it seems far removed from national security, it is the idea that if we don't have a healthy domestic market, steel production would suffer and it would create a national emergency. But this was probably the outermost and aggressive stretching of what a national emergency is and how it was defined. Next slide, please. So, of course, as soon as these tariffs come down, there are a number of challenges. One of the most significant ones begins in VOS selections, where 5 small businesses brought suit before the Court of International Trade, the CIT, challenging the reciprocal tariffs, the ones on all the other countries. And then shortly thereafter, 12 states, Oregon and many others, went before the CIT to challenge both those reciprocal tariffs against the other countries, as well as the trafficking tariffs focused on Canada, Mexico, and China. By the end of May in 2025, a three-judge panel of the CIT grants summary judgment to the businesses and to the states in a consolidated order. They say that these tariffs do exceed the president's authority under IEEPA, and they permanently enjoin the government from imposing these tariffs. That order then gets appealed and is heard relatively quickly by the Federal Circuit Court of Appeals, which affirms it. So these tariffs get struck down at the trial level, they get struck down at the appellate level, but they can't really be finalized in this analysis until you get to the Supreme Court, which of course, that's where they go next. And I'll kick it over to, well, actually one more slide because there's another case, and then I'll kick it over to John. Next slide, please. So the learning resources case is the one that ultimately goes up to the Supreme Court. Interestingly, this case was not filed at the CIT. It starts off in the district court for the District of Columbia. And that was a case around the same time the judge also found the tariff to be unlawful, stayed the order until the appeal could be heard. The government tried to appeal this to the DC Circuit, but because of some other procedural posturing in the case, this was already on the Supreme Court's radar because a lot of people wanted to go straight to the Supreme Court. And the Supreme Court said, you know what, let the lower courts figure this out first. Give us a couple of cases that we can look at, and then we'll take up the appeal. And ultimately, that's what the Supreme Court did. They took the VOS appeal, they took the learning resources case on their own volition, merged everything together into now we're going to be able to evaluate these cases on the merits, and not just for emergency relief or injunctive relief. And with that, I'll turn it over to John, all the cases now at the Supreme Court.
Thank you, Joe. Excuse me. So on February 20th of this year, just about a month and a half ago, the Supreme Court issued their decision that basically says that IEEPA does not give the executive branch, the Trump administration, with the authority to impose either of the tariffs, the trafficking tariffs or the reciprocal tariffs. The court was very clear that in its assessment of the administration's arguments from a single paragraph that Justice Roberts included that really just outlined the issues, the arguments, and what the court's job is to do. The court also made clear in this decision, by the way, that the Court of International Trade has the exclusive jurisdiction over tariff issues, removing any further doubt that there is another avenue. Can I have the next slide, please? So this is the paragraph taken directly from the opinion that I referred to a moment ago, where the Justice Roberts summed up the issue, the arguments, and how he viewed the court's role. Clearly, they said IEEPA tariffs do not authorize what President Trump was trying to accomplish, or the way he was trying to accomplish it, I should say. It did not say what the statute would do. They did not say what other avenues the president could have taken for his policy decisions, which is among the open questions that a lot of people had after the decision was issued. But probably the biggest one is, does the government have to give the money back? And that's what at least the Supreme Court left open at the time. Next slide, please. So that brings us to the Atmos Filtration case. Atmos Filtration, pretty small company. A week after the decision had issued on February 27th, 2026, filed a complaint and a request for emergency relief, seeking the return of the money in light of the learning resources decision at the Supreme Court. Judge Eaton, who announced he had been appointed to or assigned to handle all claims regarding the IEEPA tariffs, within 5 days issued a sweeping order telling the Customs and Border Patrol that you need to refund all the money to everyone who's paid it in. I'm sure you have the systems in place for doing this, CBP. So give them the money back. And this, this order, this decision sort of became the standard or I should say, the platform for a dialogue in the court's docket between uh, the Customs Border Patrol, the court, and Atmos Filtration to air out how this refund process is going to work. So clearly, we're going to get refunds, but now how the process is going to work is the next big decision. Next slide, please. So among the reasons that the CBP gave the court within 2 days after this order, a lengthy declaration uh, filed by one of the Customs Border Patrol Executive Director of Trade, um, basically explaining to the court, with 330,000 importers making, 53 million entries for payments, uh, basically they're saying court that this is gonna crash our systems. But what we are doing to try to comply with this court's order is developing some new capabilities within its record system. The record system, for those familiar with the importing process, is called the Automated Commercial Environment, or ACE. And they were creating a new, basically an add-on to ACE called Consolidated Administration and Processing of Entries, or CAPE. That is how they intend to process all of the refunds and claims for refunds. Next slide, please. So I
Right.
think
So we've got now, Kate basically has 4 parts, and we're going to walk through each of those in turn. Joe is going to start by discussing the claim portal. And the key here is that it's going to have to be the importers who are doing the work. And starting with the claim portal. Can we go forward one, please? Thank you.
So the claim portal is the first step where the claimant, the importer, the submitter, all the same thing, uploads a CSV file with the summaries that they're seeking the refunds on. The CSV file is just an Excel file, comma separated value. This is something that can be quite a big file. There's a lot of software that people use, and again, depending on the size of the importer, some of them are very familiar with this. Some people are going to be dealing with this system for the first time because they hadn't dealt with tariffs until these recent ones. So that's one of the signs to kind of consider. Had you been paying tariffs previously to these executive orders, and also, did your tariffs go up? Now, what happens once this file goes in? There's a basic file level validation that occurs to make sure that all the required fields are filled out. Anybody that's done a website kind of knows there's the fields with the red asterisk, and if you don't fill it out, it just doesn't let you go forward until there's something in there. And then the format, is this file readable, formatted the correct way, and does the submitter, match the importer's record? Is that claimant identity, the same as the importer? And this is very strategic on the government's part, because they only want to be dealing with the importers because they don't want to deal with all these potential downstream claims. Which is something that the importers have to potentially consider. Once you get through this file level validation, now they know they're dealing with the right person who actually, paid it to the government. That's who the government wants to give it back to. And then everything else is, a mess that the government's going to say you guys have to sort out. There will be entry specific validations within the data to confirm that these are tariffs and that these specific entries have at least one HTS number. There are certain HTS numbers that are not subject to tariff, that are subject to other tariffs. This isn't the stage where they get into that. They just want to make sure that the stuff that's being put in there is just not essentially brazen fraud or being submitted by somebody that's not, applicable, not enabled to receive the refund. So this is a little bit more of a technical type validation to walk through these entries. And again, the system's being built out and may change, but I mean this seems fairly straightforward. Next slide, please. The second step is going to be, mass processing, and that's after that technical IT validation. The form was filled out correctly. We're dealing with the right person. This data does involve tariffs. The idea is that the computer will remove the IEEPA HTS numbers and recalculate the duties as if those IEEPA tariffs had never been declared. Essentially a reset. Let's go back to the time before the executive orders. Let's use the pre-existing stuff. Let's get rid of all of the extra money that was paid there. And that's really what that component's designed to do. Again, you might have a form with 1,000 entries. Only 100 of them might actually be ones that have an HTS number that is covered by either the reciprocal tariff or the opioid-related tariff, the trafficking tariffs. Next slide, please, and over to John.
Thanks, Joe. Joe got to talk about the first two steps, basically, where it seems to me, in my own personal opinion, that where the most things could go wrong. But once you get past those two screens, those two modules, it is time for review and liquidation or reliquidation. What that means is once the claims have been filed, processed, the CBP wants to at least have an opportunity to review the claims. There may be, for any variety of reasons, just to spot check or audit, what have you, different claims, and maybe make some adjustments as necessary. The CBP has also stated in some of their recent reports to Judge Eaton that they are building out some additional functionality within the CAPE system that's going to hopefully even streamline that process. What exactly that means, I don't know. They haven't reported that yet, but we shall see. Next slide, please. After review, when the liquidation or reliquidation date finally arrives, and the CBP has done whatever they think they need to do manually, entries will be refunded. So ACE will direct those entries to a specific refund in the module that will be transmitted electronically to a designated bank account by the importer of record. And there we have it. We will have our money back.
Well, let's pause for a moment about that electronic transmittal, because I think that's an important point. This administration wants to do away with any paper checks. So if you don't have a bank account designated up front, and I presume does that have to be designated when you're setting up the claim portal, when you're going into the claim portal? Is that going to be one of the required entries?
To become I'm pretty sure, I'm about 99% sure that to have an account or access to the ACE system, you actually have to have a bank account on file, something where that you can use to transmit payments and process refunds. Because in the typical system of tariffs, and I'll go into that very briefly. Putting IEEPA side and all these special processes for refunding IEEPA tariffs. When a product comes into the United States, it is declared, so to speak, and the importer will create a file or create an entry within the A system that essentially tells the government what it is, how much it's worth, and it will include the harmonized tariff system. It'll include the harmonized tariff system number that is appropriate for this product or whatever it is it's been imported, and it will make a payment, and the importer will make a payment of the tariff based on that entire entry. Typically, what would happen is the Customs Border Patrol would have just under a year to either what's called liquidate, which essentially means assess, and they can say, okay, we agree with your entry, kind of like somebody filing a personal income tax return, or the government can take a look at this and say, oh, wait a minute, I think you made a mistake here. And then you get into the process of figuring out, who's right. If you if the government just accepts your liquidates your claim and just says, okay, importer, you're all set, you're off to the races. If the government says, the CBP says, wait a minute, you owe us more money, you owe us less money, well, then you have to make a formal protest. And a formal protest is fairly easy form to fill out, giving all details about why you think you're right and why you think the CBP is wrong. And you submit it to another unit within the Customs Border Patrol. If they choose to, and at that point you have two options, obviously, they allow it, or they say, no, we're right, you're wrong. And if it's the latter, then you could have to take your claim to the Court of International Trade to have a court decide, exactly what the outcome should be. One thing to note is that this liquidation, or this protest, I should say, of a liquidation has a 180-day time frame. So if you do not submit that protest within 180 days of the liquidation date, you are most likely, I'm almost entirely certain that you're out of luck. You're time barred. There could be some equitable reasons why that 180 days should not apply, but those are too rare at this point to really even talk about.
Well, I think that's actually a great transition into our next slide. And now we're getting to the meat of it. And if you're an importer, what do you do? Joe, can you give
Sure.
a little more? We can build on where John was.
In the 180 days that John mentioned is probably the key deadline to remember. And this is when the tariff's been liquidated. Now, keep in mind, there are unliquidated tariffs out there. Many of the IEEPA tariffs will be unliquidated simply because, it hasn't been, that long. But I mean, if you were paying tariffs shortly after these executive orders were issued, your tariffs may be liquidated, and that starts the 180-day clock. So you really have that time period to consider. If you can deal with the unliquidated tariff, I mean, that's where you can similarly potentially get the government to understand that these issues are going to be corrected. And that's where the government seems to have started in their filings with CIT. They said almost like, let's stop doing these tariffs going forward. Let's deal with the most recent tariffs because they're unliquidated and we can easily adjust those. And then we'll deal with the liquidated tariffs essentially last, because those are the ones that have kind of sat out there, have been finalized. They need to be reopened and reliquidated. So if you're sitting on liquidated tariffs, you probably want to get the protest in there and be more aggressive, because that's probably the lower priority for the government, since they are working backwards. Um, and then it's really that 180 days from the liquidation date. Of course, the government, like any other litigant, is hoping that they will just have some people go away. And there are a lot of very small tariffs, especially with the administration eliminating the de minimis exception. I mean, there are, consumers, people at the airport that have paid very, very small tariff that certainly aren't going to do anything to try to get that money back. But where people will have an issue is when they're a smaller importer. The big businesses are going to have a lot to do with here. The people that have only paid very minimal tariffs are just going to let this go. But this is where you have to really consider the size of your business, and if you kind of fit in this area where you started paying tariffs, pretty early last year. And you've got a sizable enough amount where it makes sense to push forward here. The protest is essentially administrative procedure action with the Customs and Border Patrol folks. Now, the ability to go to CIT also exists. And generally speaking, I mean, there are questions as to whether administrative exhaustion or procedural default can trump any type of failure to submit on the administrative side. So that's why that first deadline of actually filing something with customs is really important. But again, since a lot of people will be filing with customs, there is a potential incentive to file that complaint at CIT to show them, you're serious, and get, more attention quicker, preserve those court rights. Although, again, in typical process, the administrative process is what you really have to pay attention to, because if you screw up there, it can impact the court case. That being said, this is a little bit more unique because you're dealing with ultimately, a statute that the court found did not delegate the power to the president. It's essentially unconstitutional if the president takes power that is not delegated to him. So, setting aside questions of the technical procedure, importers are likely advised, and again, we're not giving legal advice, but if they have a sufficient dollar amount at issue, it does make sense to protest with both customs and file that complaint with the CIT. And there were a lot of people that even before the Supreme Court decision came down, they had already filed seeking refunds and really tried to get themselves to the front of the line. I mean, that procedural issue doesn't necessarily control. It creates more of a practical ramification. If the government has to go to court to deal with you, they're going to look at your administrative file as well. I mean, that's just the case when you're dealing with, these parallel actions here. Another thing to consider is, many importers work with brokers. A lot of these brokers are going to have a lot of work to do, and they're probably going to emphasize and prioritize the largest dollar amounts, the largest clients that they've got. And this is where sometimes a smaller importer has to consider whether their broker will be able to pay attention to their own deadlines and submit data on their behalf effectively and timely protest. One of the big areas to look into is, what is the importer's contract with the broker? Does the importer have the obligation to nudge the broker along and ask for their help? Does the importer have the obligation to, deal with any refund? Or is there kind of a full service contract where the broker has agreed to take on, especially, knowing that, there was a likelihood of these tariffs being struck when those trial level decisions were made? Has the broker engaged in an agreement that would allow them to do more and take on more responsibility? So that contract is really important, because ultimately that's going to govern, the obligations the broker has. And again, if you need the assistance, you can shake the contract with the broker and tell them that they've agreed to assist, and that you want to make sure that they give you the paperwork that you need for the filing, the information, assist, whatever it may be.
Well, let me follow up on that because we have a practical example here. Um, so there's an importer that we got a question about an importer where FedEx Logistics was handling the clearance and payments for years, where they transmitted a 5106 for the importer, so the importer of record is still the other party, not FedEx Logistics, and FedEx Logistics is not pursuing refunds on behalf of that importer, and I suspect on others in that situation. So that importer doesn't think that its own bank account was ever given to CBP. So they're trying to figure out what to do, just some general frameworks. One of them, obviously, from my perspective, is that CAPE isn't open. And so some of the things we were talking about, you actually can't do at this time. But so one question is, do we have any sense of when CAPE is going to be live? But two is, what other things could be done in this context?
So I can talk a little bit about that, David. CBP has been telling the court in its filings, they submit weekly updates to the court, has been telling the court that they expect CAPE to be up and running by the end of April. They've given some status reports where they estimate the percentage to completion that they are on each of the different modules. They seem to be making progress. But the question from this particular question raises a very good issue, and that is, will CAPE somehow address that particular situation? And I'm also curious to know how this particular importer may have handled refunds previously. So, I'm assuming, as much as I hate to assume anything, particularly with all things government, but hopefully that's been accounted for within the system.
And if we look to other administrative agencies, I mean, this is something that the government has done, very quickly. I mean, we saw the Paycheck Protection Program and small business lending. We saw the ability to, put out, a lot of funds and process things differently in a few other settings. They are used to dealing with a situation where, the person that originally dealt with the government may no longer be there. They may be bankrupt. They may have assigned a claim. And part of their process here is making sure that at the beginning, it's the importer that's dealing with them. Changing things like address or bank account or that. I mean, that's something that, the government has used. For instance, pay.gov has allowed people that have, government obligations to, update their banking information and use that across a variety of government websites. There may be some integration. There's a lot of different systems in the government, and certainly several administrations have been trying to streamline this without, sacrificing security. These again, there's sometimes a reason to separate people, say, IRS tax returns and bank account information there from, Social Security and from, a Fish and Wildlife permit that they might need from Interior. But they are likely to, especially given the time constraints here, rely on some of the existing infrastructure. And, that has included working across agencies and using other agencies' information to validate data to prevent fraud. And again, I mean, that's something that, has to be considered here because the Federal False Claims Act would still govern. I mean, that's a key issue. And we expect anytime people have the ability to get money from the government, whether it's PPP, stimulus programs, tax credits that are refundable, there's going to be a certain amount of fraud there, and the government tries to build in a system to validate and ensure, but a lot gets through. And I think that's another reason to potentially act quickly. But again, we are waiting on the government to put the exact system in place.
So a related point on that, I guess, So if I think the first port of call has to be go to your broker, logistics provider. If they set stuff up for you, make sure that you're getting access to it and that you're going to have to coordinate with them if they've been running things, but in your name.
Yeah, I'd say that's exactly right, David. But I also think that, pointing back to some of Joe's comments and this question you just asked is, likely the reason why we've seen uh, thousands, literally thousands of new claims filed in the Court of International Trade uh, since the learning resources decision was issued, because it's a lot of businesses basically, I'm assuming again that they're saying, well, wait a minute, if the government makes a mess out of this refund process, I want to make sure I'm in line. I want to protect my downside. So, consider it, I guess, insurance. It's essentially what it is, because you can file your claim in some of the orders issued by Judge Eaton, any claim seeking this type of relief is going to be automatically stayed until this process runs its course. But at least you're on record, and at least you've protected your downside.
Well, that raises another thing about the process. We have another question about whether the Court of International Trade will require reliquidation of all tariffs. To the extent you had a tariff that was liquidated prior to so that the 180 days may have passed or was about to pass as of the moment that we got the Supreme Court decision. At that point, maybe there was no refund claim filed because people didn't know that they had a claim. So is there any chance of reliquidation of all IEEPA tariffs?
There is, and I believe that's part of what they are part of Judge Eaton's orders, part of what CBP is up to. And, the triggering date, frankly, could be February 20th, 2026, when the world finally realized that the tariffs imposed under IEEPA, these tariffs imposed under IEEPA were not, uh, the government lacked authority to do it. As a practical matter, uh, the first liquidations of these tariffs probably only occurred within the last few months, because it does take, I think the average is 314 days from data entry to liquidation. So they're hopefully only a relatively small number of such claims that need to be reliquidated.
Right. Well, thanks, Joe. Should we maybe shift gears and talk about what to do if you're a downstream buyer?
Sure. One thing to wrap up on the importers, though, the last
Ah,
bullet point here, they always talk about, if at first you don't succeed, try again. Well, what happens if you succeed on the first try and the government gives you a big pile of money? Um, you may have to deal with insurers. You may have to deal with downstream individuals that claim that you pass the tariff costs on to them. So, I mean, there is a transition there. So, I mean, this slide talks more to the importers, and John will cover the downstream. But one of the things that exists under federal procedure is what's called an interpleader action. And that is really exactly for a case like this, where the government wants to wash its hands. They give the money back to the importer, and then they say, you deal with this problem. You go deal with the insurance companies, private equity companies that have bought rights to refunds, two or three wholesalers downstream, retail customers, potential class actions. Um, a way for the importer to figure out what to do with this money if it's not clearly theirs is to file this interpleader action, and then that allows them to bring all of the litigants into federal court, provided there's minimal diversity, meaning that one defendant has to be from a different state or country than the importer itself. And again, that helps to avoid a lot of state court litigation, because ultimately what could happen is you have 3, 4, 5 different contracts. One is your insurance contract that requires a AAA arbitration in Connecticut. Another one with your wholesaler that requires, litigation in the Court of Common Pleas of Allegheny County, Pennsylvania. There's a third contract that, requires, arbitration in Texas. So, while the contracts will control a lot of the potential rights and how this tariff was passed on, if it was directly or indirectly, the actual ability to get everybody in the same room will be very difficult, especially when you have contracts that typically have conflicting clauses. The way around that is this federal action. Again, not warranted for everybody, but if there's, a very large amount, millions of dollars at issue that, require, multiple parties to be in the room to discuss, this is a procedure that, should be considered. And again, the reasons for that, John will get into is, we talk about the downstream rights for the people that are essentially locked out of applying for the refund directly, that nonetheless want to make a claim towards that money. But yes, next slide, and over to John.
Thanks, Joe. So clearly, only importers of record have the ability to make a claim from the Customs and Border Patrol. So the downstream buyers, and I'm going to put downstream buyers really, I'm going to talk about it in two different buckets. One bucket are the ultimate consumers, the people who may have ordered a pen from Amazon or, someone like that. And then there are sort of, the other businesses. Maybe a construction company needs a certain kind of widget that's only manufactured in, pick a country. They go to their supplier and say, hey, can you get me this widget? And the supplier will say, sure. And they bring it in from, I don't know, pick a country, Germany. So the widgets come to the US, they get to the port, the importer, the construction company supplier, they, make their appropriate entries into the A system. Taxes or tariffs are assessed and maybe even someday ultimately liquidated. And then the widgets get sent to this construction company. So now this construction company that may have paid, I don't know, say 50% more, again, I'm making up numbers, 50% more than they would have, in 2024, only because of tariffs, can say, well, hey, guys, great, you're going to get this money back. What about my money? And that's where your contract, this fictitious construction company will have to look at their agreements with the importer. Specifically, what does it say? Maybe some of the more sophisticated contracts are going to actually have clauses in place that say, cost plus tariff. Arguably, if you get the tariff back, you should get that money back. But not all contracts, I think, are going to be that crystal clear. And there are many other ways for a downstream buyer to pursue a claim against the importer it hired to bring this product to the country. Claims of, I think the most common one would be good faith and fair dealing. That's implied depending on the state you're in, but I think most states agree that it's implied in any agreement that you have entered into, along with your obligation to act as sort of a fiduciary when you're signing these agreements. The other bucket, next slide, please. The other bucket are what I call the ultimate consumers. They have remedies that are similar to the downstream buyers, but there are lots of consumer protection statutes out there. Each state has its own sort of consumer protection group of laws that will, may give consumers the authority a claim against people they're buying their products from. So we've seen there are many, many, many more than the two I have listed here, but these two I picked for a couple of reasons. First, the FedEx claim, Reiser v. FedEx. First of all, what we heard from FedEx pretty early on in this process is that it's their intention to return any tariff that they have collected and charged off to a consumer. They had done a good job, frankly, I think, of uh, separately stating what the tariffs are, what the costs associated are, because now we're hearing, how there are also things you might see like a fuel surcharge when gas prices get, pretty high. Uh, that's a pretty clear, I think, outcome that we're faced with. Who knows exactly how it's going to work out, but because they separately stated the charges and made the promise that they'd return the money, I think consumers will see that. Uh, this other case involving Costco is where they actually went the consumer protection route, claiming that Costco failed to disclose the contingent nature of the tariff. So far, that complaint is still valid. It's still active. Um, Not sure exactly where it is in the process, but I think it illustrates what uh, could happen, what downstream buyers, what importers need to think about as they, claim their refunds for the tariffs that have been paid. So these are all considerations. Everybody should look at their contracts, look at their agreements, look at their course of conduct with the different parties that they do business with when thinking about tariffs.
Well, I think that then takes us into, since we've been talking about the potential claims against importers, can we flip forward a slide, please, and talk when you're if your client is an importer, what potential defenses might there be? So we talked a little bit about the contract. So if you're reviewing a contract between an importer and a buyer, what are you looking at in the contract
If
to provide your potential defense here?
Yeah, if I'm if I'm representing, say, well, either party, I'm going to look and see how specific the language is. I'm going to say, I'm going to see, well, does this contract spell out in an itemized detail uh, what it is I'm paying for? Um, or is there something in this contract that says, hey, here's what it cost. You're assuming the risk. You bought it now. You know, this is what you agreed to pay. So sorry, I'm not going to give you a refund. That's partly a business decision, partly a legal decision. But though, the contracts could be very specific, in which case there's probably not a lot of litigation involved, or maybe less specific, in which case there could very well be some litigation. And then people will have to make business decisions to decide whether or not and how hard they're going to pursue a claim.
Yeah. The next one is, we've talked about this on the retail side, and I do think that this is an area where I wouldn't be surprised to see class action firms looking to bring claims a la Costco, um, if they for against large retailers. Um, and so the question there, like if does a retail purchase qualify? I don't, Joe, do you have any thoughts on the likelihood of success on those kinds of arguments?
Think generally that, you do have some type of contract when you purchase a good, but a lot of that's more towards, the product liability and just general warranty of what the product is. You see a lot more tort actions and, false advertising and things of that nature. Or sometimes there's statutory actions. You didn't print the receipt out the right way and break things down, or separate things out. But I mean, there's certainly a variety of ways where a claim could be brought by a retail purchaser. Maybe more on the otherwise side than the contract side. But at this point, there's nothing like this specific instance that closes the door on anything. So I think we will see some creative arguments. But again, it goes towards, some of the other issues of, well, what was stated on a receipt? Was the tariff treated separately? Were goods just generally charged out at higher prices? What were the communications around that? A lot of people did get emails. A lot of importers decided to ask people directly if they would assume the risk of tariffs. Was that done? Or was this just, hey, there's a price increase, do you accept it? I think that's going to be a very fact and circumstance specific analysis, which can sometimes limit class actions, except when you have those same facts and circumstances repeating for thousands of consumers against, very large importers.
Right.
But
So Joe, like an example, like let's say, there's the statement on the website saying because of the tariffs we've had to raise our prices. That's like the thing that a creative plaintiff's lawyer is gonna point to, I presume.
sure, I mean, it stands to reason. Again, I'm not picking a side here, but it stands to reason that when they advertise our price is X because of Y that's beyond our control, when you take away the Y that's beyond their control, they should be able to go back to price X. And if we weren't actually giving you money for that profit and you got money back from the government, shouldn't that money come back to us? Um, it's certainly a populist argument that's going to make sense to people sitting in a jury box. The question is going to be, does it get that far? And again, I mean, that's where the legal analysis is going to come in, is to what was actually the expectation, what induced the purchase, what was the meeting of the minds. I mean, it really comes down to, what are the terms of a contract, and are there any gap fillers that exist? Again, commercially, there's a lot of gap fillers under UCC. In that retail and consumer side of things, there can be some similar gap fillers, just in consumer protection statutes. It can be what the reasonable consumer would believe, and again, that can very much change state by state, form by form.
Yeah, I think that also links to the question of what happens, how much was passed on, because I know there were a number of vendors who held the line as long as they could and did not believe that they could pass on the tariffs. And at some point they had to raise prices because they couldn't sustain it.
Yeah, some of that is, as you asked that question, David, it brings me back to sort of my construction company type uh, analogy I made a moment ago. And as these widgets got passed off to the construction company from the people they bought it from that imported the materials, how much of that did they really, if the agreement isn't specific enough or is silent on the issue, how much is the increased cost in goods the result of just inflationary issues, shipping costs, things unrelated to the tariffs? Maybe the price of the cost went up 50%, but how much of that was really tariff-based increase? And that's going to be some of the other issues that if things get contentious, some of the issues that are probably going to have to be flushed out in some sort of discovery proceeding.
Well, I think at this point, like to see if we've got any more questions. Oh, actually, wait, before we go to questions, I should take a few minutes and talk about taxes. Let's jump forward one slide. So one of the things to think about here, is that if you've paid a tariff and then you're getting the money back, how's that going to hit your tax return? And the good news for a lot of people, the learning resources was decided before their tax returns were due, calendar year taxpayers particularly, folks with a January fiscal. A lot of retailers, they've got time before they have to make the final decision. But you kind of got to, if you did have a closed year where how did you report the tariffs? If they were deducted, you have the potential for an income inclusion. Now, if they were capitalized and the product was unsold, do you have to go back and effectively adjust the basis? Or do you have income now? And again, if you're an accrual method taxpayer, if you're rather than cash method, and you're aiming to get a refund, when is that refund actually fixed and determinable, the right to the refund? Because that's the moment when you've got to make the adjustments. If you're cash method, you might have a little more window. And of course, if you've got a larger group that's going on, if you've got a corporate group and you've got one group member selling into another group member, look at the transfer pricing documents and what the transfer pricing documents require. Do they properly address tariffs? And you might have to make some intercompany pricing adjustments there. So just want to put that on everyone's radar as well as one of the many corollary consequences to deal with here. And with that, we'll kick over to any additional questions. We've got one here just asking to confirm whether the Court of International Trade's order included both the trafficking and the reciprocal tariffs.
Well, I think the answer to that is yes. That's certainly their intention.
Yeah, and that's what we're talking about with IEEPA tariffs, the ones that are now held unconstitutional. Are there any other questions from anyone? And remember, if you can't ask now or think of something later, we're always happy. Send us an email after. And so to that end, as we're approaching 2:00, I want, on behalf of Saul Ewing, to thank every one of you for joining us today for this webinar. And again, I'll remind you that we are going to be sending a follow-up email with our materials from today. We think we answered everyone's questions as they came in. If there were additional questions you have, please follow up by email. Our contact information will be coming over with the follow-up of the materials. And you can also, of course, find us on the website, and also you can find us with the resources tab right now.
I did see one other question.
Yeah.
Sorry, one other question just popped in regarding what is liquidation, and that's just the finalizing of the amounts that are due. It's just what the customs folks use to mean when they kind of fix the calculation and say that this has been finally calculated. So unliquidated is what we think you owe, and then liquidated is what you actually owe. And of course, reliquidation is, well, because of this change, we have to go back and recalculate our final decision.
Thanks. So again, thank you all for participating, for listening to this. We're happy to answer any follow-up questions you might have. Please reach out to any one of us. And we hope that you enjoy the rest of your day. Thank you.